welcome to Mediating Against Public Entities. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association, and today I am delighted to introduce our speaker, Rhonda Mallory. Rhonda is a mediator at Signature Resolution with over 35 years of legal experience spanning both public and private sectors. Her extensive background includes leadership roles at Caltrans and the California Department of Justice, where she oversaw litigation involving public entities, civil rights, and eminent domain, giving her deep insight into the complex dynamics of government-related disputes. Known for her resolution-focused approach and commitment to civility in the legal profession, Rhonda brings a nuanced understanding of the approval structures and procedural challenges that often accompany mediating against public entities. We can't wait to hear what she has to share with us today. Rhonda?
Thank you, Ella. So this presentation is not just for the plaintiff's bar or plaintiff's attorneys. It's for anyone basically who has any type of case with a public entity, whether it be co-defense counsel or whatever, and even for public entity attorneys. But it certainly is focused more on hopefully trying to educate the plaintiff's bar with the challenges and the obstacles that kind of go on behind the scenes for the public entity attorneys in trying to get authority to mediate or settle the case. And so hopefully the takeaway here at the end of the program will be time. We need time to get the case prepared and the information to the powers that be, and also information. So we don't want to do those at the last minute. So those are kind of the two takeaways that I want to start off with, is time and information. I do want to apologize. I had to cancel this a couple of weeks ago because I got COVID, and so I apologize for any scheduling issues that it may have presented to you. All right, so, and I'm still getting healthy, so hold on one second, please. All right, thank you. All right, mediating with public entities. So I had prepared an article that was kind of the genesis or the basis for this presentation. And in looking back at about the article, and then also the subject matter title is Mediating Against Public Entities. And so, that's okay. Thanks. Mediating with public entities. I decided to change it to mediating with public entities because number one, it really should be or try to be a collaborative process. The more information and the more time and the more you can understand what goes on, in order for the public entity attorney to get the information and the authority that they need for settlement, for mediation, hopefully settlement, hopefully the more that you can appreciate what goes on. And what this presentation is not, is it's not giving the secret keys to the kingdom. It is not, putting the roboways to see what's going on with the wizard in the background, because the reality of it is there is no such thing. What I'm going to talk about here today is, pretty basic understanding, makes sense type of an approach, but it's one that everybody involved needs to remember and to hopefully embrace in order to make the mediation or ADR process at least beneficial to both sides. All right. Let me begin. Next slide, please. Okay, this is kind of a tongue-in-cheek, or maybe perhaps a tongue in a baby's mouth, the case may be, about some frustration that you may feel when you're dealing with a public entity. It is felt by all. It's unfortunately or fortunately the process that we have, and so, yes, you may want to cry. Next slide. But just so you know, we're all in this together because we all might want to cry. Now, I'm hoping that the majority of your mediations and even just your litigation in general with public entities is as seamless as possible. But what this presentation hopefully highlights is just to educate you on those situations that might be out of the ordinary, out of the norm, and what to do as far as trying to address those issues to make sure that that everyone can be on the same page and have a successful mediation or ADR. All right, next slide, please. All right. So the state, counties, and cities all have different processes for obtaining settlement authority for mediation. And even within one entity, they may have different processes depending on what type of case it is. Employment, for instance, might have one process where they get their mediation authority or settlement authority. I'll just say settlement authority. Tort might have theirs, and eminent domain or any type of land use or property might have theirs. I know I come from the state, and so my 20 years of state practice essentially is with Caltrans and with the AG's office. I don't pretend to know the processes of the 58 other counties or the 482 cities and municipalities in California. So the majority of what I'm going to be talking about is state related. However, having spoken to other city attorneys and deputy county counsel, I know that they also have their processes and their timeframes that they need to adhere to. And so although it may not be specific or as specific or as protracted as the state, they still have, similar challenges. Okay. All right. Generally, the bigger the entity, the more process is involved. And as stated, since I was with the state, which was the biggest entity in California, I can, speak to some of the protracted processes that, yes, may not make sense, but it's just, it's the world that we live in. And let's say a slip and fall at a city, at a small, let's say small city public entity, a slip and fall on a park might be able to get authority for mediation much faster than, let's say, something having to do with the state and depending on what level of authority that you're looking for. Smaller entities may use retained counsel rather than the deputy attorneys general, which are counsel that work at the AG's office, represent those public entities, deputy attorneys such as Caltrans, deputy county counsel, or should have said deputy city attorneys as well. So many of the smaller entities, just to kind of know who the players are and who you're dealing with, many of the smaller entities may not have their own litigation or trial counsel. And so they use retained counsel in order to represent them in those types of cases. And again, I'm not talking about, I'm mainly focused on litigation because there's a lot of other transactional and other components to government as well. But right now we're focusing on litigation, civil litigation. I will say that the retained counsel that some of the smaller entities may use are typically very, very good attorneys. They know they're a client. They know the processes that their client demands. And so although they may not be an employee or in the legal division of that particular entity, they, for the most part, are darn good and they know what they're doing. All right. So the more authority requested, the longer it takes in the multiple processes. And sometimes the legislature, governor's office, board of supervisors for a county, a city council for a city, or other governing board involvement in approval. So it really depends on, again, the entity and the amount of authority requested. So I'm going to describe a real life situation that I had on a case that I supervised when I was at the AG's office. And I bring this one up because it was probably the most protracted process of any case I can think of in the last 20 years. But it was for a lot of multiple reasons. It was a very, very tragic, sad case where 3 women were on the beach and a bluff above the beach area failed and fell on these 3 women who were all from the same family. And to make matters worse, it was in front of many other family members. And they were there to celebrate one of the ladies being cancer free. can't remember what type of cancer it was. Anyway, tragic, just horrible, gut-wrenching, pull at your heartstrings type of a case. But it was a very complex case because we had private defendants, we had another public entity defendant, we had the state of California through one of its departments as the other defendant, which is the one that I was supervising. So we had a trial date. Don't ask me when it was, but we had a trial date, and and I say we, I shouldn't say that, the both public entities had filed a motion for summary judgment on multiple legal issues. And I believe it was going to be, the MSJ was going to be heard, let's say in May of that year. I think the trial date was September, if I recall. Anyway, because time was of the essence, and because time, and it was a case that, should be settled. For a lot of reasons, it should be settled. So we went to mediation in January, all the defendants and the plaintiffs. And I remember it was really long, to like 11 o'clock at night. We were all tired. But we actually did come to an agreement. Now, what's important to know about this is that it's important to educate yourself and your clients as to some of these processes. So all counsel were very, very experienced counsel. They've dealt with public entities, or they represented public entities. And they knew going into it, the state of California, we could not actually say that the case was resolved for whatever amount, because it had to go all the way up for legislature approval because of the amount in issue. So we finally, through this long mediation, late at night, finally came to a number. And so pursuant to the agreement that we did that night, we indicated to everybody that, yes, this is what the AG's office is going to recommend for settlement, but we can't say that it's settled because there's the governing body, the legislature and governor's office, and everybody going up to that has to sign off on it. So we knew it was going to be a long process. The plaintiffs knew it because their attorney had told them about that, because we had communicated with that with all other counsel. And so we were essentially settling this case in principle. But anyway, along the line, it could have been the settlement could have failed. At the same time, we all agreed to postpone the hearing of the motion for summary judgment in order to try to see if this case could be resolved. So that happened in January, and then for a multitude of reasons, and all the parties involved, all the people had to sign off on it. It finally went to the legislature, and then they were out of session, and then I think they went back in October. I think it was January, it settled in principle, and then it finally was approved in November of that year. So I think, what, 10 months, that was the longest case that I'd personally ever worked on, that took from settlement through payment, so 11 months. Anyway, just to use that as a highlight, that's certainly exception, not the rule, but it can happen. And the more that you as counsel can appreciate these possibilities and can advise your client, the better off and the less frustration, hopefully, others will have. Okay, next slide, please. Okay, differences from other parties. I was in private practice for 15 years. I did medical malpractice defense work for about 4 years, and then I was house counsel for Allstate. From the point in time that I had left private practice, house counsel at Allstate, and gone to the state of California, I'd been practicing attorney for 15 years. I had mediated hundreds and hundreds of cases. And so when I got to the state, I thought, how different could it be? Totally, completely wrong about how different it could be. First, and these are kind of the 4 takeaways as far as me as a practicing attorney back in the day, that I highlighted as differences right off the bat from private practice to public entity practice, at least public entity, again, at the state. Okay, number 1, the process for obtaining authority is more complex and time consuming, 100%. So in private practice, let's say I had a mediation scheduled for June 1st. I would have been in contact with my client insurance defense is usually claims adjuster, maybe claims management, perhaps, my senior partner or manager, et cetera, from my side of the aisle. And we would have been updating each other as to, what we thought that the value would be, and they knew it was said in deposition, and, hopefully I was doing my job and sending those status reports. And so theoretically, a case is, let's say, June 1st, mediation date. I could take, 2 weeks, sometimes only took days, sometimes it took a few weeks, depending on the complexity of the case, and the level of authority. Still, that's a reoccurring theme, no matter private practice or public entity practice. But I could usually get some authority within, a few days to a week or two. So I foolishly assumed that was what it was also when I went to the state. So I think it was the very first case I mediated. It was a tort case. And I remember speaking to my supervisor at the time. We were just kind of going over cases, and I said, okay, well, this case is set for such and such date. This is what's going on. He goes, okay, let's talk about this, blah, blah, blah. So we talked about the analysis and the liability and the damages and everything you need to properly evaluate a case for potential settlement. And then when I told him what I was going, what I valued it at, he said, wait a minute. Um, that has to go, I have to sign off on it, and then the deputy chief counsel has to sign off on it. And because of what you expect to the value to be and what you want for settlement authority, chief counsel has to also sign off on that. So I thought, okay, well, yeah, I'm used to that. I'm used to people having to sign off and review and approve. So how long could that possibly take? Because I was used to, maybe a few weeks, 3 weeks on the outset. So not so when I was at the state. Informed me. He said, no, it usually is about 2 weeks turnaround for each level. And it just depends on, what's going on. This obviously isn't the only case people are looking at. And so I foolishly totally underestimated the time that it took to get to the level that I wanted, because there was, in addition to my self-analysis, there was 1, 2, 3 levels that had to look at it. So that was the first thing that I noticed coming from private practice to public, is that just the timing is much more protracted in the public entity arena. The second thing that I noticed, which differences from other type of parties once you're in the public entity realm, is you're not able to pivot as easily once the mediation should new information arise. So again, having come from private practice, I mean, hopefully we all know, the information that that we should know about the case before the mediation occurs. That's not always the case. And sometimes it's, no one's fault that something just happens at the last minute. And certainly we all know that can happen. But it wasn't the second mediation I handled at Caltrans, but it was one of the first ones that I handled, was in the mediation. And I believe, if I remember right, it was, liability dispute. I thought that liability was, kind of thin as far as the plaintiff was concerned, but it was a big damages case. I think I had a motion for summary judgment on design immunity pending at the time. And so even though I was pretty confident that the motion for summary judgment would get granted, obviously there's no guarantees, and that's, kind of where you're hedging your bet when you have pending motions and you try to take a case to mediation and get it resolved. So I thought that I would eventually prevail on liability. However, because of the big damages, it needed to have some offer on the table for the plaintiff. So while we were in the mediation, the plaintiff attorney said, oh, by the way, Mrs. So-and-so went to another doctor, a training doctor, through her HMO, and he is now saying that, I think it was laminectomy, and the surgery has to be performed. Whereas beforehand, both sides were under the impression that the surgery, she said she didn't want it, she was not going to have it. It was iffy whether or not it was actually going to be performed. And even the plaintiff acknowledged that as well. But somehow now this new information, it changes it. I mean, you're talking, back in the day, it wasn't whatever it is, 100,000 plus general damages plus time off because I know she was a physical laborer and so she was going to have to take some time off. So this new information changed the value of the case. I mean, needed to put more money on it. And again, coming from private practice, I was used to, calling claims management or calling home office and saying, hey, this is new information. Can we offer, more than we've evaluated the case at and blah. Well, not so easy with with a public entity. Not that you can't, it's just a lot more difficult to pivot once you've known a certain, facts or what you believe certain facts are about the case, and it's been evaluated by multiple levels, and that's kind of what it is. So we ended up, continuing the mediation and it eventually resolved. But that was one of the other things I noticed that was not as easy to pivot once you were in the mediation process. Number three, the post-mediation process can also be more time consuming and complex. Again, private practice, you settle a case, I think maybe even claims handles it. It's been a long time since I've been in private practice. But the paperwork is somewhat minimal and you can get a check, at least back in the day, within, 30 days, sometimes 2 weeks. And then that's get your dismissal, request for dismissal, everything's done really quickly. But that is not so with some public entities. It's even to the point, it depends on where the funding source comes from, and that's where it kind of gets convoluted, and I could do a whole other presentation just on funding sources. But it does depend on if it's state controller's office that's issuing the check, the settlement check, or a functional unit, or another department. So it's oftentimes not the public entity attorney cannot say, at a mediation, that yes, it's settled on such and such date, payment to be done within 2 weeks, 3 weeks, whatever it is. So those are usually more open-ended and more time-consuming and complex procedures as far as the type of paperwork that's involved. And then the last kind of highlighted difference from coming from private practice to public was that most of the time, or not most, but oftentimes the client representative is more likely to be an attorney rather than a claims adjuster or anyone like that. If you are, for instance, Caltrans in the tort, I think it's a tort case, a dangerous condition of public property. I'll use that one because that's one that gets addressed a lot with Caltrans, gets sued for that quite often. So there's no client per se, but the legal division hierarchy or management chain of command is the one that has different levels of authority. And so, oftentimes they'll be the one going to the mediation with you. So it would be me as the handling attorney, and then somebody within the legal division who has the proper authority. Likewise, at the Attorney General's office, which I don't know if you guys, it's confusing, I know. So I'll use the two state entities that I'm familiar with. Caltrans is the Department of Transportation, Caltrans, and they have the legal division, which is the second largest litigation firm in California, for California. The Attorney General's office is a little different. It works more like a private law firm, but for public entity departments and agencies. So one's a legal division of that actual entity, and the other one is more like a more traditional attorney-client situation, but in the public realm. And this can be a good thing, and it can be a bad thing, depending on which. You have another attorney there, in the mediation with you, and it's so they have their own experience and their opinions, and again, not to make a judgment, it could be good or bad, but it's just different. I was used to having a claims adjuster being the representative, or someone else from a business be the representative, but with the public entity, sometimes it's an attorney. Okay, let's see. Let's go to the next slide, please. All right. Welcome to bureaucracy. And anyone that's dealt with the government knows that this is can sometimes be very frustrating. It doesn't make sense. Why is this process, needed or done? And we get it, and it's a true thing. But to try to have maybe a more positive spin on the bureaucracy, um, the good thing is the reason that the checks and balances are there is because these are public funds. This is taxpayer money that's going to fund and to pay these settlements in mediation or post verdict, whatever it might be. And so, it's a good thing. It's not just one person saying, "Oh, I think it's this much," and it's not, or I value it this much. You've got lots of different areas, lots of different people that are vetting it, multiple eyes on it for their own analysis. And so, again, try to think of it in a positive spin, if you will, that it's protecting public funds and taxpayer money. So that's how I try to look at it when the frustration sometimes gets to us as well, because it does to the public and the attorneys as well. Okay, to understand kind of this chain of command that I have discussed before earlier. So generally, it's the handling attorney who has primary responsibility of the case. So this slide is to kind of hopefully explain why things are so slow when, in a perfect world, some of this may not make sense. But generally, it's the handling attorney who has primary responsibility of the case. You deal with that person on a day-to-day basis. The person works the case up, analyzes it, and is the starting point to evaluate liability and damages and to request settlement authority from the client. So this is the person that, you're going to depots with, you're going to case management conference with. It's the one that's, primary responsibility for the case. But in the public entity world, there's then also a chain of command, which is a little bit more, rather than private sector, it's a little bit more, I would say militant, but it's a little bit more military, how about that, in nature, as far as decisions and authority that need to be vetted up the chain of command. So the public entities and their chain of command, which is usually multiple levels of authority that review the settlement authority evaluation. So let's say I'm the handling attorney. I have a wrongful death case in a state park. I am the one that has worked it up. I know what's been said in the depositions. I know what discovery is revealed. I know, hopefully, most of the case, or all the case to the extent that you can. And so I'm going to then prepare my analysis for the chain of command so that people those up the chain of command can sign off on it. And it's far more, I say it's far more, most of the times it's a lot of information is required. These settlement memos can take a long time for the attorney. And again, this is, it's not like you have one case, so you have other things going on. It can be dozens of pages depending on what type of case it is. On the bluff failure case that I mentioned earlier, it was a highly, highly technical case with erosion and engineers and things of the like. So the settlement memo for that was, I don't remember how many, 33 pages or something. It was a lot because there was a lot of information. And because we were going to be asking for a lot of money and we knew the legislature was going to be involved, every I had to be dotted and every T crossed. So the settlement memo is prepared depending on how long it is, much more simpler for a simpler case, more complex for a higher authority or more complex legal issues case. And so that's prepared by the attorney handling the case. And then at least from the state's perspective, the AG's perspective, it goes up to the next level of authority, which is the supervisor or the SDAG, who then will look at the settlement memo, may have some questions, usually will edit it for content or other reasons, or they may have say, why wasn't this person's deposition taken and isn't this important? So you then have another pair of eyes that are vetting that evaluation that the primary attorneys handled. And then depending on the amount and the type of case, it can go, a couple, 4 steps above that, 3 steps above the handling attorney. So everyone within the legal division then has representing the public entity has reviewed it. They feel comfortable, after the process, they feel comfortable with the amount requested. They feel comfortable that all the information is needed in order to request that amount. And then the next step. The chain of, okay, so sorry, start reading this. The chain of command will review the evaluation, may ask for more information. Okay, I went over that, or may disagree with the requested amount. If that occurs, the process takes a step backward for further evaluation, which I think I just explained, but it can, put a cog in that process, if you will, if there's additional information that's needed, or there's someone that disagrees with the value, either it being too low or too high. The next one is there could be 4 levels of authority or more. I just stated that. It's kind of the public entity version of the tower as far as additional authority. And then once everything's signed off on the legal counsel division, then it goes to the client for internal review. So for instance, I'll use the CHP as an example. Let's say it's an excessive force case, and they're asking, $4 million in settlement authority, using that number. So the AG's office and the handling DAG and the SDAG and the SAG and the CAG, and the state loves acronyms, by the way. They all sign off on it. Then it goes to CHP, using them as an example, an excessive force case. And then it goes up their chain of command, who are all attorneys. There's the staff attorney, who's basically the one dealing with the primary handling attorney from the AG's office, again, using the AG as an example, and then assistant chief counsel, and then general counsel, depending on what type of case and how much. 4 million, definitely general counsel would be involved. So that's just one example of how that would happen. And then retained counsel on those cases where they may not, be an actual public entity attorney, and it might be outside retained counsel. My understanding is that they have to follow similar paths for their public entity clients within the process of that public entity. And then you may have additional issues if in fact they have like an SIR, a self-insured retention limit. And if it's a case that's going to be in excess of that SIR limit, then they have to get the SIR, the people that are involved with whoever the PRISM or whoever it is, after the SIR limits, they have their processes that they have to also get involved with and do whatever it is for those processes, which I'm not savvy to those, but I do know that they exist. Okay. Next slide, please. And I forgot to mention this earlier. I apologize, because I was going to actually do questions. And I know that there's some in the chat. So I was going to do them as I went, but let's see. Okay, no, we're all good there. All right, we'll take them afterwards. Okay, pre-mediation. So now that you've seen a little bit, heard a little bit about all the process and all the time and all the people that have to look to get authority before we can go to mediation, for the public entity can go to mediation. From the next question is, okay, so what can I do? I'm stuck with those processes, I understand, but what can I do in order to represent my client the best that I can, and to try to ensure that the mediation, we'll just say mediation rather than ADR, that the mediation is successful, or at least beneficial, to my client. So here's what I would suggest the takeaways, especially is to the plaintiff's bar, but this goes to the defense as well. Because you need to have your case prepped. So number one, know your case. And I could be wrong about this, but it seems in recent years, some cases go to mediation before they're ready to go to mediation. And, key depositions haven't been taken, or there's some other issues that neither party knows the answer to, or maybe there's a potential, let's just say, surgery that no one really knows, if it's going to happen or if it's going to be recommended, etc. Anyway, so number one, know your case. this helps you. Even if the case doesn't resolve in mediation, it helps you. It helps both sides. It helps both sides in filing or opposing any type of dispositive motion. It helps you have confidence in order to advise, either of your clients as to the risks and potential value of the case. And so it's not for naught. Even if the case doesn't resolve, please know your case. And in order to do this, you have to take key depositions well in advance of mediation so the public entity can have all the information needed to evaluate it. PMQs are important to take because, no matter how, no matter how much you prepare your witnesses or your employees, stuff happens in depo that you just don't have any idea that that was going to be testified like that. So it's best if everyone knows, what's going to eventually be evidence. So take PMQs, take, important experts. I'm not saying you have to take every expert, but take those that are going to be the big ticket items or the big issues in dispute. Take the parties, take whatever percipient witnesses, especially if it's maybe treaters, doctors, medical providers. Again, this helps both sides know the actual evidence rather than thinking what's going to happen. I mean, there may be a report where, witness Mr. X says X, Y, and Z, but then in deposition, that changes a little bit. So, and I know there's two schools of thought. Sometimes people like to go to mediation before they, expend a lot of time and money and energy and effort on the case if it's going to resolve. But bottom line, the more that you know and the more prepared you are, the better. Okay, number two, I would say communicate. Let counsel know you're interested in mediation if you are early on. This signals to the other side they need to get their ducks in a row, the other side meaning public entity counsel, and they know what they have to do and how long it takes. So I don't know if this is a trend or maybe it's just a trend that I've seen more, but back in the day, we would have demand letters or we would have 998s or we'd kind of have meaning the defense bar would have a little, some idea of what the plaintiff thought the value of this case would be. Or people would start talking about mediation, soon after written discovery was completed. And it seems, again, I could be wrong about this, but it seems that now no one wants to blink. No one wants to say, hey, do you want to go to mediation on this case? Or, they may take it as a sign of weakness, whether it be on either side of the fence, plaintiff or defense. And I think that's wrong. I think you should communicate with the other side that, hey, I know we have a lot of discovery yet to do, but is this, something that we think that we should mediate? And if you communicate with your opposing counsel and you can even, just ask them, I think this is a $5 million case. What's that going to take on your side? And they may not agree with it, obviously, but what's it going to take time-wise on your side? How many levels do you have? How many levels have to see it? I mean, they're not going to probably give you all that specifics, but they can say, yeah, it's going to take me about, 90 days, 60 days to get any type of authority. So let's set the mediation and, buckle down and make sure we can get all the information that we need to try to resolve this case. I just think that there's no reason not to discuss an interest in mediation early on so that everyone kind of has that, same objective or same goal to do what they can to get everything done that needs to be done in order to go to mediation. And I will say here, I know sometimes pre-mediation, or excuse me, pre-mediation, pre-filing, can be done. In the government world, it's a little more difficult because of the 6-month statute. So unless you have like all the evidence right from the beginning, everybody does, it might be a little bit more difficult. Not that it can't be done, but because of the claim statute and the 6 months filing deadline, it's a little harder to get some public entity cases into pre-filing mediation. But for the right case, it might be something you want to consider. The timing of mediation is important. Dispositive motions, governmental immunities. So the government has a lot of immunities. a lot of qualified immunities on certain areas, design immunity for dangerous condition, and a whole host of other immunities that dispositive motions may be successful for the public entity. Um, when I was a defense attorney, and I don't even know if this is not a right or wrong thing to do it a certain way, but it's something that should be considered by both sides. So oftentimes I would want to get my motion for summary judgment or motion for summary adjudication on file as soon as possible because they're immunities, they're legal issues motions, and not a lot of discovery needs to go on with that. And because it is what it is, and like they're legal motions. So to the extent you can get one on calendar as soon as possible, it might behoove both sides because then you see what you're up against if you're on the plaintiff side, and you can see how strong your arguments may be if you're on the defense side. So again, it's just something to be considered. I usually would like to have a pending motion for summary judgment before I went to mediation so that it's, pending. I think that possibly can give some leverage. But you never know. Even if, the motion gets denied, doesn't mean that the other side's going to prevail or the plaintiff's going to prevail in trial. But it's just something to consider. Is the timing of your mediation, especially in conjunction with dispositive motions to dismiss MSJs, etc. Let's say. Okay, I think that's it on that one. Okay. Oh, one last thing on the motion, the timing of the mediation. Some people may have different thoughts about that. Wait until after, the motion is heard and then go to mediation. But I know as an attorney, if I can resolve a case and before I have to do a motion for summary judgment, if it's gonna be, resolvable, I'd rather do that than having to, MSJs motions dismiss much less, but MSJs can take a lot of time, energy, and effort. And, it's just something to be considered because they are a lot of work, and it costs the clients money to do them. So, I mean, arguably, do they put that towards settlement rather than paying, if it's the AG's office, Caltrans is a little different, and other entities, city, county may be a little different, but it is still time, and money out of that entity's pocket, if you will, having to oppose or file motions, dispositive motions. Okay, let's go to the next slide, please. All right, so your case, you've got it all teed up, you have, what the key people, the key witnesses are going to say. You've picked a mediator that you both like and trust. So here's kind of some of the little nuances at mediation that's a little different for public entities. The first one, I kind of touched upon this earlier, but don't throw new important information into the mix at the mediation. Unlike some private parties, defendants, there's less of a chance of using this new information to reevaluate the case while at the mediation. I gave you the example of what happened to me on that, and it's true. We all recognize things happen at the last minute. Sometimes you have no control over. Personally, if something happened like that to me, I'd probably call my opposing counsel before the mediation and just say, hey, look at this, is what's going on. If you may not know. This is what's going on. Do we, try to continue this mediation, or, how do you want to handle this? But again, I really do think communication with opposing counsel is really key in addition to the civility aspect of it. I think it's also very productive for both sides. All right. Public entities cannot have confidential settlements, and there's not really any specific statute that I'm aware of, but it comes from the whole policy of transparency in government and the Public Records Act, which I assume most of you know what that is. Essentially means member of the public can request most documents except, some employment and confidential records, things of that nature. If you look at the CPRA Act, it'll tell you all the exceptions. But someone can request a settlement memo of a particular, individual if they know how to find it. And so that's just the whole transparency in government, predicated on the Public Records Act, that really frowns upon any type of confidential settlements. And then I know with, on the employment realm, things have really even expanded to private entities in that regard. So it's more and more disclosure rather than the other way around. Public entities cannot make a gift of public funds, and this is the California Constitution. This is kind of a broad area. It's like, what does it really mean? Essentially, if you want to read it, it's there. But essentially, it just means that kind of what I was going to before. These are public funds. These are taxpayer monies, and public entities cannot just make a gift, something that's not valued, just to make something go away. I remember one case that I had, a lot of sad cases. Sad case where a teenage boy had hit an electrical cabinet on the side of a freeway, and his liability would have. I had a motion for summary judgment pending, but again, very sad case, and so we did have some money valuated for the mother that was the only plaintiff. And so about halfway into the mediation, we settled on the amount, which was great. However, then the mediator came back and said, wait a minute, there's kind of a fly in the ointment. In addition to this, X amount that she's willing, after we went back and forth some time, willing to settle for, she wants to have a little memorial. I think it was a bench, a more memorial with their son's name on on the side of the roadway. And I assume that that's, not going to be an issue. Well, it is an issue, not just for the public funds aspect of it, but you can't have memorials on the side of public roadways, and it could be a safety issue. And there's lots of other non-monetary reasons why you can't have that. But also on a case, it was evaluated to being favorable, liability wise, and yet a decision was made to pay some out for it. $5,000 bench may not seem like a lot of money, but it's not, it wasn't contemplated within that settlement. And so that was one example, and actually the settlement fell apart because that's really what she wanted. She didn't want the money. She didn't care. It was her son. Eventually it did resolve, but if the plaintiff attorney would have known that that's not a possibility, presumably he would have squelched that, right away, and that wouldn't have been on the table or been an issue. So just educate yourself on what public entities can and cannot do. Also, while at mediation, and this goes, well, okay, while at mediation, there may be a mix of public and private funds, and ask who is in attendance. I always thought either public or private sector. I always thought it was very interesting to know who was in the other room. The mediator may not get permission from the other side to tell you who's in there, but it's interesting to see who's in there. Sometimes, like I remember a case, this is private practice, there was an excess carrier who said they absolutely were not going to even attend the mediation. Nothing was going to get into their level, blah, blah, blah. And then lo and behold, they were there at the mediation, and they ended up actually putting up some money for the settlement. Anyway, it's just something that I think is interesting and helpful, and maybe you want to do it, maybe you don't want to do it, but I would suggest that. Oftentimes there has to be language that gives a broad time frame for payment of settlement. I kind of touched upon this before as well. Because of the time frame, it can take state controller's office or whatever the funding source is, rather than those 2 weeks to 4 weeks that a lot of them have. You can't say, yes, we agree to X amount of money to be paid within, on or before 2 weeks, 3 weeks, whatever it is. So a lot of public entity attorneys are very kind of cagey, that's not the right word. They're kind of concerned, that's the word, about putting that time frame down because they have no control over when it's going to be issued, when the warrant is going to be issued, when the payment's going to be issued. And sometimes if they get backed up, it can take a long time. Usually it's 8 to 10 weeks, but it can be, 6 months or whatever. Just something, again, to let your client know and be aware of. Okay, also, we know some cases need to be tried. They just do for whatever reason. There's just the liability assessment is, too great, or the damages assessment or evaluation on either side is too vast, and some cases need to be tried. But we all would agree, I assume, that resolution is best for all involved. It gives closure to everybody. It's a bird in the hand. You know what it's going to be. Um, Even with a public entity, even if it's going to take some time longer than you may even think, it is a for sure thing. Knock on wood that the state of California doesn't implode, but we won't go into that. But it is a for sure thing, and you don't have to do post-trial motions. There's, all that guarantee. So it is best, resolution is best for all involved, with the caveat that understands some cases need to be tried. Another thing that the plaintiffs' bar should be aware of, and maybe y'all are already, but it's not anything I ever even used that often when I worked for the state, is assume the case doesn't resolve and it goes to verdict. You should look under Government Code 984 and Government Code 985. Those are tools that the government can use to basically extract out a payment of a verdict for 10 years. That's Government Code 984. If the court allows it, has to have court approval, obviously. I know my team up in San Diego, down in San Diego, where am I? No, in San Diego, dealt with this a couple years ago. It's again, I think I've only used it twice ever in 20 years, but that's a possibility. It could be extracted over a 10-year time period. And then Government 985 is for collateral source. So the government does have some tools that it can use that private entities can't. And that's done on the back end of a verdict. So it's, let's say the howl number is, $20,000 paid by the HMO of the plaintiff. On the back end, the government can then make a motion for that amount not to be included in the verdict. So I won't go into all of the details because I need to sum it up here pretty soon, but I would look under Government Code 984 and 985 just for your own edification. Okay. Oh, one thing I was going to say, and I did employment for 17 years at Caltrans. On the cannot make a gift of public funds, sometimes this comes into play in the employment context where the plaintiff or plaintiff's counsel wants someone reinstated or promoted, or they want some monetary increase for pension. It can't be done for the most part. I mean, can't say it can never be done, but for the most part, it can't, because it would fly in the face of CalPERS regulations, which is a whole other state entity with all their own rules and regulations. And it could be conceived as making a gift of public funds, something that someone's not entitled to, just to resolve the case. So I did forget to say that, because sometimes in the employment context, it does come up. All right, next slide, please. All right, so post-mediation. Congratulations, you've resolved your case. Now what? Time for payment. Explain that one. Just please let your clients know that it is not a short time frame typically, at least, not for the state. I know some of the smaller ones are shorter. I had a case once where it was like end of November, and I know the case settled because the woman wanted money for her granddaughter for Christmas, and she thought it was going to be, done within that time frame, because presumably her attorney said, oh yeah, it usually takes, 2 weeks, 30 days on these types of things. And then once we talked about that, as we were finalizing the settlement at mediation, he was totally shocked by it and didn't know about it and had no clue. And you know, nothing, no disparagement on him. He just didn't know, he hadn't done a lot of public entity cases. So time for payment, get your client's expectations in check because it could take some time. Post mediation paperwork. This also can slow down the process once a case is mediated. Sometimes, depending on the entity, additional paperwork and analysis has to go up for approval. Settlement release or agreement. Sometimes they're releases, sometimes they're agreements. And then the payment form, whatever it is, it has to be exactly correct. You have to dot your I's, cross your T's. The names have to be exactly the same. I had a plaintiff attorney a few years back invert the name of his client, which, you know, no, not a big deal, perhaps, and certainly understandable. But it, you know, 5 weeks later, I get a rejection back saying, well, this is not consistent with what the settlement, you know, the settlement release says. So that can start you over the clock running as far as processing the payment. So just make sure everything is perfect. It has to be, you know, really by the book. Otherwise, it can be a further aspect of delay. Budget issues. Oh, wow. Okay, I'm going fast. Budget issues that may require multiple payments over more than one fiscal year. So yes, there's a pot of money, but every agency, department, and even, you know, district and functional unit may have their own well, they have their own operating budgets. So sometimes you're going to come into a situation where, and this has happened in the employment context more because it comes out of at least at Caltrans, it comes out of the operating budget for that particular district. And so sometimes if the settles in, you know, May, they don't have enough money to pay for the full settlement, whatever it might be. And so there's a request that once the new fiscal year begins, which is July 1st of every year, then it'll get paid out of that. I had at the AG's office also on a bigger $5 or $6 million case where we were out of funds for payment of a particular settlement, and we had to go to the next year. Actually, we didn't because they ended up having enough. So he actually got it, or she got it within that same fiscal year. But again, communicate with plaintiff. Any of you public entity attorneys, let them know that this may happen. Communication, communication, communication. It diffuses any frustration and lets everyone be on the same page. So that is something, I don't know if cities and counties do that. I know the state has done that because I've handled it many times myself as far as payments over more than one fiscal year. Okay, next slide. All right, here's just some basic random tips. This actually happens public practice, or excuse me, private practice too, but public entity counsel may not even know the authorized settlement amount. Some clients do not share that information. You may have done the settlement memo and you know what your chain of command recommends, and then it goes over to the client and they don't let you know what they decided they're going to give. So just a little caveat, some clients don't share that information even with their attorneys. Number two, public entity counsel is accurate when they convey the time frame, challenges, and agreeing on a mediation date. I had one attorney scream at me saying I was lying that I couldn't do a mediation for 90 days because, you know, I had to get my ducks in a row and get the authority. It takes a long time. It does take a long time. Hopefully I've conveyed that, how long it takes. It just takes longer than you think it should or would, and maybe that's the case, but they're not yanking your chain or dragging their heels. It is a reality. Public entity is not the enemy, although there may be some exceptions. That was a just kidding. You know, public entity counsel wants to resolve the case as well. There's nothing better than having a case, you know, 30 days before trial and having your having all the binders in your office, or in my case, loose on my desk, and then it resolves at mediation. It's just like, you know, it's like this breath of fresh air. And so they're not the enemy. Give them what they need so they can request the amount of authority that you know will hopefully resolve the case. Doesn't always happen, as we know, but you know, most of the time it does, as we know. I think what 96 to 97% of all cases, I don't remember what the latest stats are, of all filed cases do resolve short of trial. All right. Getting your case worked up early on before the entity files its dispositive motion may be helpful to both sides. I kind of alluded to that before. I think it's just smart to do because then you know on both sides what you can oppose that motion with, and you know the case. So getting your case that worked early on is beneficial in all areas. And then probably the most important is be patient. It takes a long time, and hopefully that I've conveyed the reasons why in this presentation. Let's see. Okay, last one. All right, second to last. Okay, how to have a successful mediation, more of the same preparation, develop your case early, taking depots and whatever you need to know your case and work it up. Perseverance, understand the long but necessary authority process before mediation can occur so that it gets teed up early on and you and opposing counsel are both on the same page. And then patience, educate your client and yourself so you don't have the mishaps of getting people's expectations, inflated or just unrealistic because you're dealing with a public entity. And it also keeps frustration, hopefully, to a minimum for all counsel and for clients. All right, last. All right, so this is this is kind of just a little Zen thing. Take a deep breath because even with all your preparation, everything you've done, a great mediation brief, a great presentation, um, some cases don't resolve. Vast majority we do, we just discussed, but some cases just don't resolve. So just realize that all that work that you've done, it's not for naught. It will do you well if the case has to get tried or if there's a second mediation or whatever it may be. But you only have control over what you have control over. And that applies to public entity attorneys too. I mean, we get frustrated with our clients just as much. If we've recommended something and they go a different route or whatever it may be. So anyway, just take a deep breath and recognize that you've done the best you can to prepare your case for the best resolution, and you can only control what you can control. All right. Thank you very much. If anyone has any questions, I know I went over a minute. If anyone has any questions, I don't see any in the chat. Unless I'm not.
We
Oh,
actually
wait.
have two questions
Oh,
in the
I'm sorry. I didn't see that. Yes. Okay. Oh, PMQs. I'm sorry. Person most qualified. What are PMQs is the question. So a lot of people call them PMKs, which is a pet peeve of mine because that's a federal term. Although I work federal courts as well, but in California, they're called persons most qualified. So that's a category. Let's say you want to take a PMQ of we'll use the state park situation again, someone who authorized the design plans for a sidewalk or a stairwell. So you don't know who that person is. So you would do a deposition notice for the person most qualified, and then whatever that category may be. It's the public entity that gets to choose who the PMQ is, not you. You can individually notice someone in their individual capacity, but it's the public entity that decides who the PMQ is. All right. A question for later, are 998s enforceable against public entities? Yes. But I've seen the argument that prejudgment. Okay, let me read this. I'm sorry. A question for later, are 998s enforceable against public entities? I have seen argument that prejudgment interest is punitive and therefore not recoverable against a public entity. You are correct. Prejudgment interest you cannot have against a public entity. You also cannot have punitive damages against a public entity. All right. In the code, there's government code sections that are right on point to that. Anyway, if anyone has any specifics they want to run by me, feel free to email me at my email address, which is on the front page, I believe, of the presentation. I'm also a texter. If you want to text me on my cell, it's 858-883-1100, 858-883-1100. And I apologize, I went over. Be happy to answer any questions for anyone else. Thank you.
All right. Thank you, Rhonda. This concludes today's presentation. Thank you so much, and thank you to our audience as well. Have a great afternoon, everybody.